Hi, my name is Cameron Weir, and I'm here as part of the Vethin Law Firm's video educational series. And today I'll be talking to you about how injunctions can be used in partnership disputes. What is an injunction? An injunction is a tool that is used to stop a bad actor fast. A lawyer will ask the court for a special order that requires or prevents a party from taking certain actions. Courts issue these orders where money won't fix the damage that can be done. The circumstances in which you need to move for an injunction when you have a partnership dispute include such instances as a partner stealing company assets, a partner misappropriating the company name, a partner making material changes to the leased premises of the company business, and a partner spending and hiding company assets and profits.
So, Joe, when is it appropriate to obtain the injunction?
Well, it's appropriate to obtain an injunction when you've got a risk of irreparable harm, and that is composed of three elements. First of all, the threat and harm has to be imminent, means it's about to happen immediately, and if the court doesn't do something right away, something bad is going to happen. Next, the harm has to be irreparable. Generally, that means throwing money at it's not going to solve the problem. It's not like regular damages.
So give us an example of what irreparable could mean.
For example, in the context of a trade secret, if your trade secret is disclosed publicly, you lose that trade secret protection. So you want an injunction to shut someone down to keep them from disclosing that trade secret and ruining your protection. That would be an example of an imminent threat.
And Cameron, we were talking about partnership disputes as to what may be irreparable harm in a partnership disputes. What are some examples that our friends can look at to show that, hey, that's irreparable harm in a partnership situation, an injunction may be appropriate?
Sure. In a partnership situation, often the company will be in a location that is a leased premises, and if the partner that has control of the leased premises is making material alterations to the leased premises, then that is a situation where an injunction can be used to stop them.
And I think a lot of times here, guys, is you have theft of trade secrets, theft of intellectual property, theft of a company's name or trademarks. All those things would lead you to the courthouse to say, Judge, we need an order to stop this person or persons. Would you agree with that?
I would agree with that.
Okay. Once we agree that we have to get an injunction, or your client must get an injunction, Cameron, what would be the next step?
Well, then you need to make a decision about what kind of injunctive relief you want to get. See, there's a temporary restraining order, and then there's also a temporary injunction. For a temporary restraining order, you can obtain that without the target party being present, without giving them notice. And in a temporary injunction situation, you are required to give them notice. Now, the issue with a temporary restraining order is that it has a maximum effective range of 14 days, and then the court can extend it for another 14 days if you show good cause. With a temporary injunction, that stays in place until the court ultimately decides the underlying lawsuit.
And Joe, with the temporary restraining order, again, this is for the state court proceedings, that you may approach the court on an ex parte basis, meaning the other side may or may not be there, but realistically, the judge is going to ask you, have you contacted the other side? Have you called their lawyers? Let them know what's going on. Have you experienced that, Joe?
Yes, often judges want you to try to confer with the other side before coming down for a temporary injunction. There are exceptions. For example, if notifying the other side might cause some harm, cause them to do something that would immediately damage the property or the subject matter of the lawsuit, then you can get around that requirement. But most judges want you to make an effort to talk to the other side first.
So, Joe, is that true? Have you been before a judge where the judge asks you whether you conferred with the other side before signing off on a temporary restraining order?
Yes, most judges want you to make an effort to confer with the other side before they will sign off on a TRO. There are a few exceptions to that where you have a situation where there's a risk that the defendant will do something that will cause immediate harm, for the example, destruction of property. Otherwise, most judges require you to make an effort to confer.
All right. Once the temporary restraining order is in place, the next step is to obtain evidence that you can use at a hearing, because as we said, the temporary restraining order may be done ex parte without the other side being there. The next step would be a temporary injunction. And with a temporary injunction, it's a full-blown evidentiary hearing. So to prepare for the evidentiary hearing, what are some things that we should be looking for?
Well, you want to get into doing some expedited discovery. You want to find out all the evidence that you can to prove the harm that you were stating will happen when you were requesting the injunction. So if you were stating that the other partner is taking company assets, you want to get into the bank statements to start showing where those assets are being misappropriated.